that will attend to court as and when this court requires it. Thank you.
Mr. Njeru, your last soldier? Is it your last?
So this one and then Dr. Hamino.
Dr. Amino.
Thank you, Your Honor. I'll take only 2 minutes.
Professor, you said you were taking 2 minutes.
2.5 minutes. Your Honor, I'm very privileged to appear before you to demonstrate that what I did recently in my second PhD in criminal justice should be put in a maiden opening, and you are the first that I'm appearing before, so I'm very privileged. Secondly, I would like also to thank my former teacher, Simiu. I think he taught me very well. That's why I've been proceeding on. Now, the point that I want to make is just one or two. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ESCC and their mandate. I would like to apply what we call strict scrutiny. Strict scrutiny test. Law, whereby if the government raises its own legitimate expectation to validate, it is incompetency. Incompetency is aligned to rights protected by the Constitution.
Come again?
Incompetency is aligned to rights which are fundamental and protected by the Constitution. If that was the case, then that law must be narrowly, and I mean narrowly, tailored to serve a compelling interest. What is a compelling interest? I will not go into that history because my senior counsels before me have already spoken about that. How do we look into the classification of what the state has alleged? Classification, looking at the time of the search, the time of arrest, the time taken to drive, the accused, the miles involved in that journey, the manner in which the accused was transported, where the accused slept, presumably in this case, cold floor, and how the accused was arraigned in court. Lastly, Your Honor, I may not understand, and please let the court make me understand, whether the arresting officer is the investigating officer and is the judge, and is an evidence provider, provision of evidence through affidavit, which even if mandated by statute, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances in court, then there is high potency of illiteracy in the judicial, in the government executive system. I rest my case. Thank you. I think it should, because I can substitute it. Your Honor, what I mean by literacy is not literally academic schooling, but experience. And if we were to do what we call discoveries in law, the kind of affidavit you have seen here raises issues that can only be raised on discovery.
You're repeated yourself.
Thank you.
Thank you. Daktari, how long? I'm not even
I'll be
sure
very brief,
whether I will
Your
fix time for you.
Your Honor, I'll be extremely brief,
Very well.
except I'm asking for one.
Your Honor, looking at the order, which Your Honor you can have a look at, the Kitale residence is not captured. It's not there. And therefore, Your Honor, we are appealing to you that the evidence that has been annexed to the affidavit is illegally obtained. And we are not very sure that the pictures that are said to be connected to the accused person's home are genuine. And Your Honor, to cap that, I would want to refer you to the Evidence Act, Section 106, capital B, Section 4, subsection 4, to be specific. Your Honor, those pictures are not accompanied with any certificate that identifies the gadget that was used.
I love how advocates mislead their words. You're on the 6th minute, the 6th minute.
I wrap up. I yield.
So big.
I
Have you
yield.
read it recently?
I yield, Your Honor.
Honest to record.
Your Honor, I'll try to take 3 minutes at max, and you stop me if I see.
Be sure it is 3 minutes.
Stop me, Your Honor.
Yeah.
The first point, Your Honor, is just raised on my point.
Now, I expect you start with what you wanted to read.
Yes, that's what I'm addressing the question. Your Honor, Section 106, uppercase B of the Evidence Act is very clear in the manner in which electronic evidence is adduced. There is no certificate of electronic evidence annexing those pictorials. By dint of that section alone, there is no evidence in support of the bare allegations in the affidavit. There is no basis to even advance now any compelling reason.
Slow. You left me a mile to go. There are allegations contained in the affidavit.
And in the absence of the electronic certificate, the annexures are inadmissible, and the court should expand them. In their absence, there is no evidence brought to court to support the opposition to bail. Finally, Your Honor, you are told that this court cannot interpret the Constitution. Section 3 of the Judicature Act lists the sources of law in Kenya that this court is called upon to apply. This court can apply the Constitution, including the Bill of Rights. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply it in the ordinary course of the court's duty. We are not asking for interpretation. Last point. Everything remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. The subject of the proceedings is now a warden of the court. not a warden of the state. Bail and bond or pre-hearing detention should never be used as a basis to punish an accused person who is still presumed to be innocent. And I urge Your Honor to so consider this accused person as its warden